Ladies and gentlemen, I know you've been here 3 weeks, 2.5 weeks anyway. By my count, over the last 16 days, you've heard from about 31 witnesses. You have a lot of evidence presented to you. You have a lot to consider when you go out to deliver on this case. This case is taking place at a time probably not any of us would have chosen, around the Christmas season, around the New Year's season. But it brought to mind something for me. I was looking at during this season, a little book we were getting out at my church called The Case for Christmas. And it's it's an excerpt from another book called The Case for Christ, written by a reporter, like all these reporters up here. Lee Strobel, the author, was a reporter, and he set out to prove that all the stories about God are not true. All the stories about Christ are not true. And ultimately, what he looked at was the words of Jesus himself, the evidence of his acts, and the evidence from those who witnessed his acts. Ladies and gentlemen, I submit to you, that's what you have to do with this case, to determine whether Robert Shuler Smith has committed 2 conspiracies and has rendered, or has counseled, assisted, and advised the criminal defendant. You have to look at his words, you have to look at his acts, and you have to look at the acts of others who witnessed his words and his acts. That's where we see the true evidence of who the person is. What Lee Strobel ultimately decided, kind of the fall apart of the rest of the story, is Christ does exist. That was his ultimate conclusion, even though he set out to prove something completely different. Now, let me say something about this case. You know, this case is unusual in the sense that it involves an elected public official. And we expect from our elected public officials that they will carry out the oath that they have sworn to do justice, that they will protect the rights of, in the case of the district attorney, of the innocent and the guilty. But sometimes, folks, those public officials disappoint us and they abandon their oath. The most recent example we've had right here, just in the last year, Chris Epps was our Department of Corrections Commissioner for several years. Everybody respected him. Everybody expected the best from him. And we learned that, as Mr. Smith just said, what he was doing in the dark when it came to light showed that he was breaking the law. He was taking money for his office. So, let's look at some of the words of Robert Shuler Smith to determine what it is we can conclude from his own mouth about whether he was conspiring with Jamie McBride, Ivan Johnson, others in his office. I submit Walter Black is one of those, as you'll see in a moment. And as to this question that Mr. Smith just raised, how can he conspire with Jamie McBride if we dismiss the charges? Ladies and gentlemen, that begs the very question. He asks you to conclude that a prosecutor has the authority, when he or she chooses, to dismiss some defendants. That's the basis of his case, that he has that authority. We exercise that authority in dismissing the charges against Jamie McBride. Not because he was not a part of this conspiracy, but because we chose, finding that he was a lesser actor in the conspiracy, and that the conspiracy was directed by his boss, we, in the exercise of our prosecutorial discretion, decided to dismiss the charges against Mr. McBride. Now, let's look at some of Robert Shuler Smith's own words. You have these videos played to you. We're not going to play the entire videos again, but I am going to show you some excerpts from some of these videos, just very briefly. This is from the May 9th video. We refer to it here as the fishing trip video. And Ivan Johnson is saying, I can see a difference in Judge Will. Smith says, how he acts. What does Johnson says? Johnson says, towards us now. And Smith says, I'm going to get it. I'm going to get it. Keep that phrase in mind, because that phrase is not a word, I'm going to get the judge. Nobody put that word in Robert Smith's mouth. Ivan Johnson didn't come up with that word. Those are Robert Shuler Smith's own words, that I'm going to get the judge. Here again, they're talking. What is he going to do? Is he just going to keep holding on to that? Keep holding on to what? The Christopher Butler case. And what does Robert Smith say? The more he do, the worse it gets for him. The more he holds on, the worse it gets. In other words, he's making me mad. I'm Robert Smith. I'm the district attorney. He better look out. He's making me mad. You better watch out who he's messing with. And the suggestion that Johnson was some kind of plan, that the DA, that the FBI, or the Attorney General's office planted Johnson. Remember what our very first witness told us. Robert Culpepper, sitting right back there in the courtroom today. The FBI agent said they had worked with Johnson. They had done all of these tapes before they ever even told the Attorney General's office about Ivan Johnson and what Ivan Johnson had in the way of information. And what is Johnson and Smith, what are they talking about? Brother, when you engage in your business ventures, don't forget about me. And what does Smith say? His own words, brother, I got you. I promise. Whatever it is, I got you. You're my buddy. We're hanging together. I'm going to take care of it. That's what he's telling Ivan Johnson. He's not telling Ivan Johnson, you're some part of a scam that I'm investigating, that I've been investigating for a year, and I know you're a part of it. He's saying, we're hanging together. Here from the May 9th video, they're trying to figure out whether they have standing against the AG's office, standing to sue the Attorney General's office. Now, folks, did we elect a district attorney to go sue the other prosecuting office in the state? Is that what he is charged with doing? And Johnson's trying to figure out, what are we talking about? They didn't have jurisdiction in the first place to bring these charges? Robert Smith says, yeah, right. That's absolutely false. You saw the statute. The Attorney General's office has authority to bring white-collar crimes, and they brought a white-collar crime case against Christopher Butler. Here again, we need to go between. Tell me about some cases in the campaign where he met with you. You and him met with some people, the guy at the presidential field. This is the Henderson cases that they're talking about. And Smith says, no, I went to what you call a thing, the Easter egg hunting. That's exactly what Henderson told you. He got him on the program to go to the Easter egg hunt, and that's when the word came up about fixing some of these cases. Here again, they're talking about unless we go after the AG's office, we sue the AG's office. Let me say something about this. We sit here at this table, Mr. Sanders and I. We're not the AG's office sitting here at this table. We represent the state of Mississippi. The state of Mississippi has brought these charges, not the Attorney General's office. We happen to work as prosecutors for the Attorney General's office, but we brought these charges, actually, grand jury brought these charges, in the name of the state of Mississippi against Robert Shuler Smith. Is there some history between Mr. Sanders and Mr. Smith? Clearly there is. But that's not what this case is about. That's not where this case originated. That has nothing to do with the charges in this case. Do they like each other? I don't know. They may not. Do they get along with each other? I don't know. They may or they may not. But it doesn't touch at all on the evidence in this case. Here again, they're talking about the non-props, the motion to dismiss. And Smith says, well, I got plenty of them. He just won't do what I want. He just won't give me the ruling that I want. Then they're talking about who else is in the picture. Jim Wade. We're going to hire Jim Wade. Now think about this. When's the last time any of us heard a district attorney talking about hiring a private attorney to sue the Attorney General's office and to bring civil rights charges on behalf of a criminal defendant whom his office indicted? You know, we have a lot of witnesses who sat on that witness stand and they use the word never. For example, all of those witnesses from Hines County Jail said, I never had the district attorney come in saying, I want to meet with my client to the jailhouse. Ms. Rushing said that. Ms. Kendrick Johnson, I never. And I submit to you folks, you've never heard of a district attorney calling a civil rights attorney like Jim Wade saying, come sue on behalf of this defendant because I can't get the judge to dismiss my case because I won't give him the information he's asked for to explain to him my theory that the case doesn't have any merit. Lastly, just a few excerpts from the June 18th video. Here again, Johnson saying, look, I talked with Jamie. He's all upset. You can see this very well. He's upset. He wants to know, is he doing the right thing, brother? Did he make you mad? Are you mad at him? Is he going to lose his job? Or is putting all of this information together for Mr. Wade and the way you ask him to on behalf of a criminal defendant, is that going to help him keep his job? Jamie, really worried about losing his job. What else does Ivan say? He says, I want to tag along with you on that grand jury. Well, while you were putting all that up, I know what he said. June 22nd, 2016, Robert Shuler Smith had already reserved time in the grand jury to go present charges. And we know that's what he's doing because what did he say? Again, the words out of his very own mouth. Gathering evidence, just need you and Jamie to get with the detective. Then he says, I'm charging someone. You saw this earlier. I'm working on this nonstop. Will is obstructing justice. I'm putting that together over the weekend. Will, Sean, and Patrick for obstruction and conspiracy. I don't give a damn about them not being charged. This is the district attorney charged as the chief prosecutor for Hines County saying, I don't even care if the law doesn't support it. And on that same June 18th tape, what does he discuss with Johnson? Well, I talked to Mr. Wade. Mr. Wade told us, no law to support what we want to do. We're just going to be arguing that, hey, we should be able to see the Attorney General's office and make them dismiss this case. There's not even any law to support it. And lest there be any doubt about exactly what he was preparing to do, I have 4 counts of obstruction on Will, a conspiracy count on Will, Sean, and Patrick for filing false charges on Butler, January 19th. He had absolutely no basis. He had no basis in law. He had no basis in fact. He had no basis whatsoever to say that those were false charges because he didn't know what the charges were even. When he had shown up in the preliminary hearing in front of Judge Will and made such a ruckus out of it, the judge asked him, are you ready to proceed with the preliminary hearing, Mr. Smith? You say you have a right to be here. And what did he say? Well, I can't proceed on this case. I didn't bring the case. I don't know anything about the case. I I can't go forward. Ladies and gentlemen, this idea that there's some animosity between the AG's office and that's what this case is about, that's like most of these other arguments you've heard from the defense in this case. That's another smoke screen. It's another excuse. Mr. Smith just talked to you about the fact that he sent this letter to Sanford Knott and he raised serious constitutional issues. Oh, really? What he didn't also tell you is, you know what was attached to that letter he sent to Sanford Knott? Was a motion to hold Patrick Beasley and Sean Mercury in contempt, asking the judge to send them to jail for 6 months for going to a preliminary hearing. For going to a preliminary hearing, he's asking that they be held in contempt under some unfounded, bogus, unlawful argument that they improperly revealed grand jury information. The preliminary hearing was not a grand jury proceeding. It was an open hearing, just like this trial has been for the last 2 weeks. And that was, again, evidence that Robert Smith was trying to counsel, assist, and advise Christopher Butler in order to help get his charges dismissed. Now, you've heard that there was some discussion about leniency to Butler. Let me say one thing, too, about Christopher Butler. His name has been mentioned throughout this trial. The defense mentioned it probably more than anybody. This is not the Christopher Butler trial, ladies and gentlemen. This is the Robert Shuler Smith trial. Christopher Butler would have his opportunity to have a trial. And if there was planted evidence, if the MPN agents lied, if the dope was planted, if the dogs didn't hit at the right place, if Josh Ledford has some information, all of that can be tried in Butler's case. This is not that case. This case is about what Robert Shuler Smith knew about the Butler case and what he was trying to do about the Butler case. And I kept a copy because Mr. Wade read to you a lengthy list of potential witnesses at the beginning of this trial. You may remember that in the jury selection process, that he was possibly going to call as witnesses. And they've been mentioned here in this trial. But where are they? Where's Josh Ledford, who has all this great information?
The Attorney General has too much access to witnesses. You on either side. Neither side that's an improper argument.
This is argument, Your Honor.
I'm going to sustain it.
Where was in the non-process motion hearing? 2 hearings before Judge Will. Josh Ledford was not brought to either one of those hearings. Neither was Travis Turner brought to either one of those hearings. Neither was either one of the Indiana agents. You know, if there's a problem with the case.
It's court case. I object because either side has equal access to witnesses to argue. It's improper not to have a witness to proceed. It's improper.
Are you referring to witnesses that were not present at the preliminary hearing or some other proceeding?
Yes.
Your Honor, are correct. Mr. Turner was in New York before that was claimed by.
Well, that's not different thing.
All right. Objection overruled. I think he referred to witnesses who could have been present in some other proceeding and were not, or whatever.
Let me make a point.
Just argument. Go ahead.
Thank you, Your Honor. Let me make a point to you what I'm saying, ladies and gentlemen. As to the Christopher Butler drug case that Mr. Smith was trying to get dismissed, there's a simple process. You file a motion, the judge has to give consent before the case can be dismissed. The judge will ask Robert Shuler Smith for some information. Tell me about this Ledford guy. Tell me about Travis Turner. Tell me about the DVR. Tell me about why this case needs to be dismissed. Later on, Ivan Johnson asked about why don't we just provide the things that the judge asked for. Damon McBride said, why don't we just give the judge the things he asked for? And what did Robert Smith say? No, I'm not doing that. I'm going to indict the judge. He's obstructing me from dismissing my case. I'm going to charge him with obstruction. What did I tell you this case was about at the beginning of the trial? Using the criminal justice system to assist a criminal. That's what he was doing in that Butler case. He was trying to use the criminal system to dismiss the Butler drug case instead of simply, if you're going to act in good faith, then you do what the law allows you to do. You follow the standard procedure. All lawyers, particularly prosecutors, know you want to dismiss a case, you have to have consent of the judge. If the judge wants to see some information, the judge can ask for the information. Give them the information and then you dismiss your case. If that information is a reasonable request. It's a reasonable request that judge will make. And you would do it. You would do it. You would prefer to indict the judge instead. As to the conspiracy in count 2, again, it is mere coincidence that there were subpoenas issued the same day that Butler was arrested, because that Butler fraud case opened by the AG's office was opened way back in November. They had investigated the case, they were ready to go forward with the charges. They arrested him on January 19th. And the subpoenas were held in abeyance as to Beasley and your Curran. They weren't going to appear on that day. The subpoenas had been held in abeyance. They weren't doing anything in direct response to the fact that they were called before the grand jury. And, ladies and gentlemen, as to count 3, again, how many witnesses said they had never seen the district attorney show up asking at the jail to meet with my client? Those are his words. Those are Robert Smith's words, my client. The defense wants to say to you that Sanford Knott somehow authorized him to go in and meet with Christopher Butler. Sanford Knott was only hired by his own testimony. He was only hired to testify, to represent Butler at the preliminary hearing. And when he got through the preliminary hearing, his work was done. He didn't go meet with Butler until May and June. Tried to meet with him in June. He did meet with him in May and had him prepare this statement that you heard all about. Ladies and gentlemen, the evidence in this case clearly shows by Robert Shuler Smith's own word that he was conspiring. He was agreeing. There's nothing fancy about a conspiracy. You can conspire, as I told you in the opening statement. You can conspire to break the law, to commit a crime. You can conspire to achieve an unlawful purpose, or you can conspire to achieve a lawful purpose by an unlawful means. In this case, that fits the count 1 conspiracy absolutely. Robert Smith was conspiring to get a case dismissed. That's a lawful thing. You can dismiss a case as DA, but you can't dismiss it by indicting the judge. That's an unlawful means. You can't do that. Count 2, a conspiracy to make a case go away by charging the prosecutor. What did Patrick Beasley say? If you prosecute the prosecutor, which is what he was doing, he was prosecuting the prosecutor on that fraud case against Beasley, against Butler. Beasley would have been recused from the case. He couldn't have handled the case. And if he prosecuted Judge Will would have been recused from the case. And he couldn't have handled the case. Prosecuting the prosecutor was what he was conspiring to do, to hinder the prosecution. Hindering prosecution, you can do it by deception, as Mr. Sanders talked to you about. You can do it by intimidation. What did Judge Will say? I was intimidated before I knew he was going to indict me. I would surely have been intimidated if I had known he was going to the grand jury to indict me. ladies and gentlemen, the evidence from the witnesses that you have heard in this case. And I'm going to finish up with the last witness you heard from, Gail Walker. What did Gail Walker tell you about Robert Smith when it came to the Butler case? When it came, these are her words, when it came to Christopher Butler, District Attorney Smith became a totally different person. He took on a different personality. He had a different drive. He had a different motivation, ambition, and goals. Nothing stood in the way of getting rid of that case for Christopher Butler. Nothing and no one. And as she told you, she enjoyed being a public servant. She enjoyed being a prosecutor. She enjoyed standing up for the rights of victims. Robert Smith took that away from her and fired her for not doing what he wanted her to do with the Butler case. Another interesting thing that Ms. Walker said to you, remember she said, out here at one hearing on the Butler case, I couldn't tell who was the defense and who was the DA. Because all the arguments being made for Butler were being made by Mr. Smith. Ladies and gentlemen, we elect district attorneys, yes, to do justice, but to do justice within the law, within the bounds of their authority. Not over here outside the bounds, using the grand jury system, using the indictment process to get what they want. Tracy Chandler.
Yeah, 5 minutes remaining.
Thank you, Your Honor. You heard all this testimony about Tracy Chandler coming to the grand jury. What you didn't hear, except for Mr. Smith reference to the fact that grand juries are secret, is the only lawyer who appears in the grand jury is the prosecutor. There's no cross-examination of Tracy Chandler. There's no opportunity to confront her with the statement she had given to the FBI 6 months earlier in the grand jury. There is simply his suggestion, oh, this must be the Dixie Mafia. The Dixie Mafia was trying to get Stan Alexander elected. That's the most absurd thing I've heard in this trial. The Dixie Mafia trying to get Stan Alexander elected, it makes about as much sense as the Ku Klux Klan supporting Stan Alexander. That's ridiculous. But it sounds like, oh, this is a scam that I'm looking at. This is a scam. Well, where's the proof in the pudding? Where is the investigation? If he was investigating something all the way back in 2015, where is the evidence that he was investigating some scam? Where is the evidence that he was doing anything about the fact that he already knew? On that June 18th video, remember what Adam Johnson said? The Marietta hair stuff that you already knew about. He already knew that Johnson had taken money from Marietta hair. All of the evidence in this case, ladies and gentlemen, you sort through all of it, you've got a lot of it to deal with, but all of the evidence will convince you, I submit, beyond a reasonable doubt, from the words out of Robert Shuler Smith's own mouth, that he was conspiring to hinder the prosecution of Christopher Butler in count 1, that he was conspiring to hinder the prosecution of Christopher Butler in count 2, and that he was counseling, advising, and defending Christopher Butler as charged in count 3. Once you review all the evidence, I submit to you, ladies and gentlemen, the only verdict you can read is guilty, guilty, guilty. Thank you very much.
All right. Ladies and gentlemen, you now receive the instruction of the law from the court, and you have heard the closing arguments of the attorneys. The bailiff will, I think the exhibits are all in a cardboard box. Would you, lawyer, make sure that